Yeah, I'm very much privileged to welcome you all in this important webinar wherein we discuss the important judgment and in the field of the income tax. This is our regular feature, and most important part is that this this webinar is again going to start in the year of 25-26 when the new committee has come in the Delhi tax consultant here. Delhi chapter of tax consultant is always trying to do good program here on the issue of the discussion of the tax law, some other law, and when the new income tax law is coming right now, we are also making some good program on this issue here. However, we will be deliberating or we will be sharing what are the programs that is there. But in the meantime, before we start, may I request Hinesh Doshi sir, who is the member of the Managing Council from CTC Bombay, to give his inaugural remark here before we proceed for the introduction of the chairman and speaker by Richa ma'am. Thank you here.
Thank you, Sinaji. A great welcome to Pannu sir, Sunil Aggarwal ji, and everybody virtually available as a panelist and as a speaker or in some other form of the Delhi chapter. I'm actually more a night watchman because I'm replacing the president. President is traveling and hence he requested me that I request you to kindly give inaugural address and please continue initial inaugural talk, and that's why I'm in front of everyone here. I was the president of 1890. I'm still a managing council member. Friends, chamber, you must be surely aware we are in a great year, which is our centenary year. We were born or established in 1926, and we are today 100 years young, and we are celebrating our 100-year centenary, and hence it's a great experience that this committee is going to celebrate the 100th year, and we are going to have lots of program in Delhi, physical as well as virtual. And I request everyone who is there on this webinar to please become member of CTC. It is a great organization and it's more a learning experience. And once again, welcome to everybody who are here on this webinar for this great topic. Thank you, everyone. I request Richa to please take it further.
Thank you very much, sir. Good evening, everyone. So it's our honor to have Mr. G.S. Pannu, sir, as a chairman of today's session. Thank you very much, sir, for joining us. Mr. Pannu is a distinguished legal and tax professional with over 4 decades of multifaceted experience spanning accountancy, law, and judicial administration. A chartered accountant since 1985 and graduate in 2024. ITAT for 24 years in key leadership. Stewardship, national pendency of appeals reduced from 50,000 to around 33,000, achieved through policy innovations, IT-enabled reforms, and efficiency measures, including the pioneering of paperless courts, e-filing portals, and virtual hearings during pandemic. He has adjudicated over 12,000 cases, many reported in leading tax journals. Beyond the bench, he has contributed significantly to infrastructure development with respect to ITAT, new state of Delhi premises. Prior to his judicial career, he was a partner in leading CA firm, engaged in audits, valuation, and corporate restructuring, and appointed by Delhi High Court as an independent valuer in merger proceedings. Currently, sir is an advocate. He advises on corporate governance, taxation, and financial restructuring, and undertake commercial arbitration. Thank you very much, sir, for joining us today. We would also like to welcome Mr. Sunil Aggarwal as one of the panelists for today's session. He's an accomplished legal professional with over 3 decades of experience spanning direct taxes, black money law, indirect taxes, PMLA, Benami law, corporate law, including cross-border amalgamations, demerger, corporate frauds, and insolvency matter. He's a well-versed in arbitration, having been appointed as a sole arbitrator by the High Court in several cases. A former officer of the Indian Revenue Service, Mr. Aggarwal took voluntary retirement to join private practice. He has represented clients before Honorable High Court, Supreme Court, Appellate Tribunal, ED, and other forums. He has successfully achieved significant wins in high-profile matters, working alongside various eminent senior advocates. Thank you very much, sir, for joining us today.
Thank you very much.
And we would also like to welcome Mr. Ashish Garg, who is our second panelist, who is a corporate and international tax specialist with over 13 years of experience spanning compliance, litigation, advisory, and strategic planning. He has built a strong reputation for guiding businesses through complex global tax structuring, dispute resolutions, and regulatory compliance matter. Ashish ji has been a featured speaker at ICI, IFA, and SOCHAM forums, and his thought leadership has been published in leading tax journals. A committed contributor to the profession, he has served in ICI Northern Region International Tax Committee and is a member of the ITAT Delhi Bar Association. He holds certifications in international tax and valuation and has completed leadership program from ISP IMA. Thank you very much, Ashish ji, for joining us today. So
Thank
now
you.
I request JS Pannu sir to chair the session, please.
Thank you, Richa. And I think we should straight away go to the subject, and which is the Supreme Court judgment in the case of
Hayat, sir.
Hayat International Southwest Asia Limited. So, Prakash, I think you can request the speakers to start so that we can hear them, and then let's see what comes out of the discussion.
Yes, sir. Before we start, I think that Richa ma'am forget to introduce Diksha Gupta ma'am, who is here and who will be assistant. We will be assisting. She's a very bright chartered accountant, as I know her. I do not know much about that, but I'm say really thankful that Diksha ma'am has come here for his great insight on the topic, and I'm really hopeful that all of us will be great learning. Which it will be great learning for us. So now the Ashish Garg Sahab and Diksha ma'am to you for to discuss the Hayat. Now the Hayat has become more famous here. Whenever I cross the Bhikaji Kama place, I see the Hayat. Now I have to see the Hayat in a different context now here.
Thank you, sir.
And Aggarwal Sahab and
So,
Pannu, wherever required, you
Mr.
please
Sinha,
for the purpose of discussing, sir.
in the lighter vein, Mr. Sinha,
Yes,
when
sir.
you pay the bills in the Hayat, now you would know what's happening with your money which you are paying there.
Yes, sir. Now I have to ask him that how much has to be attributed to the PE.
That's right. True. So I think Diksha is done. I think she's starting, so we can wait for
Yeah. So thank you so much, Prakash ji, organizers of this program, CTC, Pannu sir, Hinesh sir, Richa ma'am, and everyone for providing me this opportunity to share this important ruling on the Hayat. So I think I'm loud and clear.
Yes.
Okay. So we will discuss in the couple of minutes what is the importance and significance of this judgment in the PE jurisprudence of India. So while the Supreme Court time and again has established laying down rights from Formula 1, Morgan Stanley and IFA, now again there is a judgment of Hayat. So we will discuss whether there is any change in the position of jurisprudence of PE in India, or is it the same which the Supreme Court has laid down in the Formula 1. So Supreme Court has laid down a couple of principles, substance over form, and they have discussed this ruling at length. At the High Court has also laying down some principles. We will discuss what all are the key facts of the decision. We will discuss the argument of both the sides, and then we will discuss the Supreme Court observations. Next slide, please. Yeah, you just present your screen, the presentation format. Okay.
Make it in the presentation mode.
F5 presentation. You need to go, I think. Yeah. Go to the next slide. Next slide. Next slide. So go to the slide number 4. I think there is some issue. Let me present my screen. Prakash ji, is this screen visible?
Yes,
Yes, sir.
make it in the presentation mode. That will be good.
This is in presentation mode now.
Okay, let's go on.
Okay. So we'll discuss briefly about the facts of the case. SECI is the taxpayer of the UAE in this case, and the India-UAE treaty was consideration before the revenue, and they entered into a strategic oversight service agreement, which is known as SOSA, on 4th of September 2008. So while there are multiple years into the consideration, the revenue has took assessment year 910 before ITAT for the purpose of adjudication. And there are other agreements entered by the UAE company with the Indian hotel, which is known as the Asian Hotel Limited. One is the trademark and know-how. Additionally, there was a entity, Hayat India, to whom they have entered into the hotel operating service agreement known as HOSA. So they are trying to bifurcate the strategic services with the day-to-day operations of the management.
Ashish, sorry to interrupt. Just give one more perspective here.
Yeah.
This Hayat UAE and Hayat India are subsidiaries of one Hayat Corporation US.
Yes.
Yes, sir.
So what it in effect means is that through the UAE subsidiary, they have entered into this oversight agreement. So also the technical services agreement and the trademark, as you rightly said. Hayat India is Hayat India, which is again a subsidiary of Corporation US, entered into with AHL the operational agreement.
Yes, sir.
Yeah, that is how. So therefore, Hayat India has nothing to do with Hayat UAE as such.
Yes, sir.
But they are subsidiary of the same corporation. That's all.
They are the subsidiary of the same corporation.
Correct.
Yeah, if I go back to the history a bit later, so earlier they have entered into an agreement with the operations and management agreement in 1993, and that agreement they have split it into the different parts in 2008. So there it comes to the SOSA agreement, and again with this HOSA agreement was signed for the day-to-day operations and management. So the idea was to kept day-to-day operations separate with the Indian entity of Hayat, and the strategic oversight functions will be taken care by the Hayat Dubai entity. So the argument of the revenue before the ITAT and the assessing officer has categorically argued that because there is no FTS clause under the treaty, so any payments made by the Indian entity, which is the AHL in this case, to the Hayat Dubai entity is to be treated as a royalty. And in additionally, they said that the Hayat Dubai entity has a P in India. So the taxpayer argued before the assessing officer that they did not have the P in India because they specifically fall under Article 52I, which is the service fee clause, and they have not satisfied the 9-month conditions over there. While their employee put together has spent 150 days in India, but they have not triggered that service fee implications. Therefore, they did not have the service fee. And because this is the specific clause under the treaty, we are not required to look into the 5.1. This is the argument they taken up before the assessing officer, ITAT, and High Court, and continued till Supreme Court. We will discuss how these arguments had been taken care by different forums of the judgment. Moving on to the next slide. Yes. Now over to Diksha to pick up some of the clauses of the agreement, and then we will discuss.
Okay. Thank you so much, first of all, for this opportunity. And as led by Ashish, so there were some of the key clauses of SOSA, which we will be covering here. First is important aspect or the crucial aspect is in the judgment is the period of the SOSA agreement. And the period is mentioned as 20 years, which is 10 years extendable. So in the hotel industry, it is a general norm that there is a 10 to 30 years of agreement, which is normally conducting. And similarly, the agreement of Hayat is factored into 20 years for a time period. Then the second important clause of the SOSA agreement is the role of the Hayat UAE, that is a Dubai-based company. The main role of the Hayat UAE is to formulate and establish the overall strategic plans, policies, processes, guidelines, and parameters for the Indian hotels, that is Delhi and Mumbai. The main aspect is not to cover the day-to-day operations because that will be governing by the HOSA agreement, which is a separate agreement. So in this strategic oversight agreement, which is SOSA, they are recruiting, interviewing, or assisting the general manager, hiring of the general manager, that too with the approval of the Indian Hotel, AHL, that is Asian Hotel Limited. Then they are formulating some of the key policies of HR, some of the other policies of purchasing policy, guest admission or hotel premises, etc. Apart from that, all these controls are happening virtually on the entire policies. However, there are some visits of the employees, and the crucial part of that visit we will be covering on in subsequent slides. Then Hayat will perform its duties from the office that is outside of India. So if this kind of services will be provided a virtual control to the Hayat Dubai-based company over the Indian hotel operations, so that a brand owner, which is Hayat UAE, can maintain the brand effectiveness in the Indian hotels. So Hayat is there was no obligation to depute any personnel by the Dubai-based company, that is Hayat UAE. But if the need arises, they have reserved a right that they can employ someone for a temporary period of time to maintain that brand consistency in the hotel of Delhi and Mumbai. So the terms of the hotel was placed in such a manner that the fees, which is Hayat UAE would be getting as a service fees from the Indian hotels, is based on the revenue. That is 0.5% of the room rent and 7.5% of the cumulative gross profits for the year. Then, which we were discussing, there were 6 employees that were deputed to India for the different roles by the Hayat UAE. These the designation of those employees were also mentioned, that is managing director, director finance, director HR, director sales and marketing, revenue management, and internal audit. So they remained in India for a total period of 1858 days, which is less than the threshold of 9 months, which is mentioned in the India UAE tax treaty, for, and that is relevant for the service PE clause, which we will be discussing in the later part. So some of the other clauses of SOSA which is relevant here is the right of Asian Hotel Limited, that is an Indian company, to receive the financial returns from the hotel operations, shall not give any rights with respect to the operations or management of the hotel to the Dubai-based company. For the operations and management, HOSA was already done, but the relevant clauses of HOSA and the importance of HOSA was not much discussed in the judgments were delivered by ITAT, Honorable Supreme Court, and the High Court. So while AHL will continue to have ownership, creating a mortgage, it is secured non-disturbance and atonement agreement was there that the lender will adhere to the terms of the SOSA. Now there was also AHL also undertake to provide a NOC for the similar entered into by the Hayat UAE, and this NOC or the non-disturbance laws was for the preservation of brand consistency, which was placed in by the Hayat UAE in the SOSA agreement. So these are the some of the relevant clauses, or which you can say the relevant factors which has been discussed in all the judgments in by the Honorable ITAT, High Court, and Supreme Court. Now Ashish to take over.
So while we see that there are various clauses of SOSA which court has relied upon, and the Supreme Court has majorly relied upon this non-disturbance and atonement agreement, which lenders has to provide that they will not do any intervention with the SOSA agreement. So this is something essential clause which Supreme Court has picked up. In addition to the clause that AHL has to provide the NOC if the Hayat is doing a similar sort of arrangement with any other hotel on the similar location, then Indian company should not have any problem in that. So while the arguments of the revenue before ITAT and High Court both are in some way similar. So we'll take on both the things together. So before the ITAT, Hayat UE has held as a fixed place permanent establishment, and they have cited the following reasons: that the UE entity has the absolute control over the day-to-day management, and they have not given much importance to the HOSA agreement. They said the entire operations of the Indian hotel is done from the Dubai. They are involved into the administration, they are involved in the finance and all spheres of running the hotel, including the banking account operations are decided by the from the Dubai entity. So it gives rights to the Dubai entity much beyond the consultancy job. So ITT has categorically pointed out that it is not a service agreement, it is the Hayat Dubai entity is doing their business in India. As regard the period of stay is concerned, the ITT has pointed out that the aggregate period of 150 days should be looked in from the perspective that this is the long-term contract of 20 years. And if I take 1 year into the consideration, your employees are available throughout the year. It's just that someone is coming and someone is going out, but your employees continuously and repetitively performing same kind of services from the premises. So the fixed place P and the disposal test is qualified in this case. So moving on to the High Court observations. High Court has categorically said that the because India UE treaty did not have the FTS clause, so FTS implications would not trigger. This is which is well accepted by the ITAT and High Court. Now coming to the royalty argument. So this argument was not much pressed or discussed by the venue before the High Court. They accepted it because there is a P constitution under Article 7. So the argument of royalty does not have much relevance here. Now the fixed place P argument, this High Court has also held that there is an overarching role of the management of Hayat Dubai entity in the implementation of operations of hotel operations of Indian entity, and they also said that they have the persuasive control over the day-to-day management. This, yeah. I hope the screen is visible, na? Yeah. And they also said that the client place, which is the Indian entity, is no longer remain a client place. It should be reckoned as the place of management of a Dubai entity in India. And particularly if we go to the para number 78 of the High Court, they cited the example of a chartered accountant office who is doing an auditing job at the current premises. As long as the chartered accountant is performing the services of auditing, there should not be any P implications. But beyond that, if the chartered accountant is running or involved into the business affairs of the client, then there will be a P implications.
Ashish sir, can you check your slides here? And because some people are telling that slides are not moving, and you please speak about the slides here because some people wants to learn more about that part here. Yes.
Is this visible now?
Yes,
Yes,
yes.
sir,
Please
it's
be.
moving now.
Yes, now it is moving, sir.
Yeah. Okay. Fine.
Yeah.
Yeah. So para number 78, High Court has given taken an example of the chartered accountant office, and they have not relied upon this because there is a thin line of difference between a advisor performing their services to the client and a situation where he is involved into the affairs of the client. When there is a that difference has been beyond the line, then it will be creating a fixed place P of the chartered accountants into the client's office. And the important aspect within the para 98, 92 of the High Court order, they have gone. Sorry.
78.
We discussed para 92 of the High Court order. High Court has said that it is difficult to accept the Hayasui employees are deputed to India would be insulated from addressing any issues other than the hotel and no specific prescription. So there is no specific prohibition to the employees to discuss any affairs or any decisions of the any other hotels of Hayat entities in India. So this is something, that argument which is astonishing to me, that High Court has assumed on the facts that even if the this is not coming out from the facts of ITAT, High Court has presumed this. So while there is a settled position of the law when it comes to the taxing statute, distribution of taxing rights, that onus of proof is on the department to prove that there is a permanent establishment in India. Now the High Court has presumed this fact and going ahead to say that Hayat employees are doing a business of other hotels in India. So if we look at the ITT decision, the taxpayer has argued that they are only working for Delhi and Mumbai hotels, but before the Supreme Court, they also said that they are also managing the affairs of the other hotels of Hayat in India, like Goa, Kochi, and other states. So this is something which is different from the stand they took before High Court into the Supreme Court. And in the Supreme Court, they mentioned that maybe due to defend the argument of the fixed place, that there is no fixed place in Delhi office or Mumbai office, they are keep on moving from one place to another place. So this is something different argument they took before the Supreme Court only. Moving on to the next slide. Before the Supreme Court, we have divided the key argument that taxpayer has taken. That we discussed that they taken the argument that there is no specific FTS clause in the India-UAE treaty. My slides are moving.
Yes. So in this aspect,
Yeah.
the main argument is that there is no specific clause of FTS in the Indian UAE. And the law behind, or the reason behind this, was when the negotiations were happening when the India UAE treaty was finalized. The only way is that the source taxation, because UAE was not charging much of there was no taxes in the UAE. So similarly, India has given the rights that FTS would not be taxable in the UAE countries, for the UAE countries. So the main factor was considered that if any consultancy services are to be provided in India, that should not be taxed as an FTS clause. And that is why there is an exemption, in a way that there is no FTS clause was introduced in the India-UAE treaty. And this kind of treaties were very popular, or these non-FTS clause in treaties were presented at that point in the 1993, when India was negotiating or finalizing the treaty. So if the argument is taken that the PE, that the honorable department is making a PE, then the need or the rationale for making, or the absence of FTS clause, is somewhere diluted, because now the department is going beyond the service rationale of making the treaty negotiations, and because this consultancy services is in the nature of service income only.
So what Diksha is pointing out to say, the India-Dubai Treaty was signed in 1992, and if we look at the history of Hayat in India, Hayat came to India somewhere in early 1980s. So there must be some arrangement exist with Indian company at that point in time also, and thereafter they entered into the first agreement in 1993. And the intention was that they not to tax any FTS income by both the countries, and that is why they have not included FTS clause itself into the treaty. And for the service fee also, the period of 9 months was provided for substantial time to perform any services by the employees in India. So this was the intent at that point in time between the two sovereign countries. So one cannot lose the sight when the agreement was entered, treaty was entered, that it should be read into the good faith. So we have not find these kind of argument before the Honorable ITT and High Court by the taxpayer side, including Supreme Court. So these kind of argument are also relevant to from a treaty interpretation perspective in view of Article 31 of Vienna Convention. Yeah, argument 2.
Ashish sir, can we please increase the font of the slide? Can we increase? Participants are asking.
Make it in a presentation mode. I feel that, yes.
Yeah.
Okay.
Okay, that will work here.
Yeah, this is fine. Yeah.
Yeah, thank you.
Yeah, moving on to the argument two, when the department has alleged that there is a fixed place PE, they gone with the assumption that because the service fee is not relevant because there is a longevity of the contract, that too is a 20-year with the ability to increase to a 10 more years, and they see the overall SOSA agreement in a holistic way, that there are so many controls in the hands of the foreign company in terms of appointment and recruitment of the employee, in terms of formulation of policy, in terms of banking decision, and also whenever they have to take any loan from a bankers, they need to mortgage the property, they need to provide a non-disturbance agreement to the UE company. So considering all the things into the consideration, revenue has argued that this is the case of a Article 5.1 fixed place P rather than a service P, which is not relevant in this case. Yeah. Moving on to the argument 4, which is with regard to the global losses, and the matter was referred by Honorable Divisional Bench to the larger bench, and they categorically said that even in the cases of global losses, India is following a Article 7.1 approach, which is more inclined to the UN Convention, and the source state has the right to tax any income arising from their state. Therefore, an entity level approach should be followed rather than the global approach. So while the Supreme Court has referred this observation at the later part of the decision, but they did not much dwell into the this argument. So in that way, if we can consider that doctrine of merger, High Court order merges into the Supreme Court order. So whether this will be a precedent for the future to in order to understand the attribution in cases of global losses. So while the revenue arguments are same before the Supreme Court, High Court, and the lower authorities, we shall not discuss it over here again. Now moving on to the Supreme Court observations. So Supreme Court has affirmed the High Court and ITAT findings, and they said that the performance of core operations, which is a factor 1, is something which is creating a fixed place permanent establishment of a UE entity. That UE entity rights are go well beyond the mere consultancy services. They are actually doing their business in India from the place of a AHL in India. They have the rights of appointment, supervision, and even appointment of general management and key personnel. They have the intervention to control pricing, branding, and marketing strategies. They are the one who is deciding how to operate the bank accounts. Even then, we discussed that there is a clause of a non-disturbance agreement into, and they go for a mortgage of the property. So all these factors they have also considered, and also Supreme Court has considered the fact that in addition to the disposal test and economic substance test, there is a test of a stability, productivity, and dependence. All these conditions, Supreme Court has therefore again referred the Formula 1 decision and reaffirmed that all these factors are relevant in addition to the substance and economic test. Second factor, the Supreme Court has considered revenue model. Supreme Court has said it is not the case that there is a fixed service fees is given to the Hyatt Dubai entity. It is based on the total turnover and the gross profit as a percentage of the Indian entity. So it is more inclined to the fact that the Dubai entity is doing their hotel services business in India. So when it comes to the Article 5.1, the business of the entity is carried out partially or wholly through a connection through a permanent establishment in India in a contracting state. The court has that the business of the UE entity is to operate the hotels, and that is what they are doing beyond the consultancy services in India. That is why their revenue model should be looked into the consideration for the purpose of determination of PE. Longevity of the contract we have discussed. Other observation we have discussed stability, productivity, and dependence. And while the our form, everyone is saying that it is the case to be applied and look through approach to be applied. But I would look at it as it is the case of a not only substance over form, it is the form over substance, and the form is the contract which was filed before the authorities, which is the SOSA agreement. And on the basis of that SOSA agreement, form was accepted by the revenue and taken as a substance. That in substance, all these activities are taken care by the Dubai entity. So when we thinking loud, what all the activities department or revenue officer will do to collate the evidences of substance, they did not take statements of the persons on oath. They did not summons Indian personnel. They did not inquire with the what Indian promoters are doing. What is the role of the Hayat India entity and the HOSA agreement? They only go by whatever is submitted through their submissions by the taxpayer. And the SOSA agreement is the form which they have accepted to create a substance in for providing their decision. Moving on to the next slides.
Sir, can
Yeah.
we please move the slides? We are slides are not.
Okay. Is it visible now?
Yes.
So I
Now
am on slide points to ponder. So there are certain factual aspects which we seems like to be a gray area in this decision. Like we discussed that HOSA and SOSA, there are two agreement that Dubai entity or that the Indian entity has entered with the Hayat Group, SOSA with the Dubai entity, and the HOSA with the Indian entity of a Hayat Hotel. So at the ITAT level, both these agreements somehow is mixed up, and the SOSA has superseded over HOSA. So the facts were not coming out properly, and the distinction was not somewhere missed out by the revenue or by the SECI to draw a line between the two agreements. So this is something we think that if those things were put in place by the taxpayer carefully before the revenue authorities with the distinction that possibility of those arguments will be taken up before the higher authorities will be much better. As regard, there was no obligation to possess, only a right to assign employees. We discussed that the agreement provides a clause that Dubai entity did not have any right to or obligation to appoint their employees in India, but on a need basis. On a need basis, just to exercise their duties or responsibilities under the agreement, they can send their people in India to perform those tasks. And if we look at the description of the employees, which is coming under ITAT and High Court order, and those functions are mainly on the oversight role or providing guidance. So there is no much harp on this, whether these are the oversight functions or much beyond the oversight functions by the taxpayer. They simply said that they are doing exercising control over the Indian entity operations. So if those functions will be discussed in detail by the taxpayer before the revenue authorities and that forming part of the ITT judgment, then that would be better for them to place their argument before High Court and Supreme Court. As regard role of owners of business operations, so before the revenue authorities, the importance of Indian company, which is AHL, was not discussed at all. So they only gone by the fact that the Dubai company is managing the operations of Indian hotel. They have not discussed that in addition to the operations of hotel, there are so many other functions which are important to running a hotel and which Indian promoters are supposed to do. The role of Indian promoters are not discussed anywhere. If this is the fact which is something brought on record, then facts could be properly appreciated by the courts and the situation could be different. Next point is the no exclusive space or legal right over the premises. So while we discuss that that legal right or any leasehold right is not required to satisfy the disposal test, and the ownership of the premises will remain with the Indian company. However, the High Court found that the hotel premises were at the disposal of Hayat UAE due to the functional control. So functional control is the factor which was discussed at length because of the control exercised through a SOSA agreement. And there High Court reproduced the Formula One decision wherein the Formula One has also cited the example of a hotel manager case of a UK Germany TT, and this judgment was this decision was not pursued in the High Court thereafter. They simply concluded with the chartered accountant example, and then said that the controls are beyond the exercise of the functions by the Hayat Dubai entity in this case.
So, in addition to what Ashish has said, that the CA example was quoted by the High Court, that was in Para 78 of the High Court order. Apart from this, the distinction or the important factor which was missing in that honorable court judgment was that Hayat UAE was rendering the strategic management or consultancy services to the Indian hotels in Delhi and Mumbai. So they were carrying on, it was held that Hayat UAE was carrying on the business of the Indian hotels. So there is a fine line of distinction between the foreign enterprise rendering the services to the recipient and the foreign enterprise carrying on the businesses of the recipient. So in this case, what was concluded is Hayat UAE was carrying on the business of the Indian hotels, which might not be relevant for the ruling because there was a separate agreement for the operations, and that agreement should also be given the due importance because the role of Hayat UAE was strategic management and consultancy. And another important factor which has been should have been deliberated more is the long duration of the SOSA agreement. So, if we see the practice of the hotel industry, there is a need for brand consistency. That virtual control cannot fulfill the entire objective of the brand consistency because in the hotel industry, you have to come over, see how they are treating their customers, how clean is the hotel, how they are providing the services. That is also an important factor. So, if the brand consistency has to be maintained, there should be a considerable amount of time that the agreement is coverage so that the brand consistency or the goal of brand consistency can be achieved. So, the strategic oversight agreement was strategically made out of 20 years with 10 years extendable term. And this is similar to the other players which they are conducting like the 10 to 30 years of time span so that the brand consistency goal can be achieved. So treating this as a permanence test in the dispo and treating this as the satisfaction of the disposal condition for creating a fixed place PE might be deliberated more upon this because according to the industry, it is the need of the industry.
Moving on to the legal aspects, which yes. Moving on the legal aspect, the first important point for consideration is whether this revenue model test, which was given due importance by all the authorities in decision, whether it will be a determining factor for existence of P in future or the tenure of an agreement is a decision for disposal test. So this is something which is it needs to be mindful because there are cases the revenue model is the test for remunerating the foreign entity. For example, in cases of a royalty arrangement, this is the passive source of a income for a foreign entity. There also the revenue is one of the criteria. So are we trying to say all these kind of arrangement where even the issuance of debentures and the return on debentures is dependent upon the IRR of the company? So all these arrangement will come to the tax scrutiny going forward. As regard productivity is concerned, the judiciary has rejected the OECD para 735 of the commentary, and they said that the Formula One ruling which lay down the test of stability, productivity, and independence, should be satisfied for creating a disposal test of Article 5.1. So they have given the more importance to the productivity. Here we can assume a situation that this is a 20-year long contract, and this is that to a service contract. For a service contract, a person will be equipped with knowledge, skills, and all to perform those services maximum by 5 years or 6 years. Not that 20 years long time will be required to perform those services themselves. So this is in that way is that the Dubai entity is running their operations on an ongoing basis in India. Like Diksha has said that in cases of brand engagements, these are all are the long term contracts, and we discussed that Dubai first came in India in 1983, and that was the first MNC hotel operation started in India. And there was a contract in place since 1993, which was amended in 2008. So before 2008 also the Dubai entity is doing their operations in India. So I don't know, this is not a matter of fact of record what happened in those years. Was there any allegations by the department on similar lines or not, and what would be the fate of the those years in view of the Supreme Court ruling? So next legal aspect for consideration is whether the Morgan Stanley ruling, which specifically talks about the stewardship activities in Morgan Stanley, what happened that foreign company has deputed their employees to Indian company to oversee their operations, whether they are doing as per the standards, policies, and protocols set by the foreign company or not. And all these activities are regarded by Honorable Supreme Court as stewardship activities. And for stewardship activities there was no trigger of a permanent establishment. So we need to see the difference between the core function and stewardship functions, whether there will be a distinction we will able to draw in future in our client cases, or how it will be dealt by the authorities. Next point is Supreme Court even observed that the service fee is not determined and fixed place fee would be the determination factor in this case. So I was thinking loud that there was discussion I was doing with one of my colleagues whether the specific versus general rule is still applicable or prevail to for treaty interpretation or not. So while I'm not able to convince myself with this argument that service fee is a specific clause in this treaty and it should prevail over the general clause or 5.1, but 5.2, if we see it always provides a illustrative list, and it cannot be override the general clause. And 5.2 always provide a complementary list which is after 5.1. So general clause will always prevail in treaty interpretation after, and this judgment reinforces this argument. Is my screen moving? Yeah. Moving on to the next aspect which we can ponder upon, the role of the deputed employee relating to the client office and service in other hotels. Like we discussed para number 78, see example, para number 92 and 93. Para number 92 and 93 of the High Court order. So whether there will be a place of management. So we know that Article 5.2 provides list of cases where the P can be trigger, branch, office, factory. Place of management is one of such criteria. So whether this place of management can also trigger a P implication. This was not discussed and argued by the revenue in this case, whether there could be an allegation that that in fact Dubai company's management is flown to India to carry out this operation through their employees by appointing key manager personnel. So is it the place of management of a Dubai company in India which is creating a P implications? So although this could be one of the argument which was not discussed, and I think this argument was somewhere discussed in the Delhi High Court in E-Fund, but because this was not given much attention and the Supreme Court has not much deliberated on this. So this is also one of the factor. Moving on to the next point, economic substance to determine the PE status. So, while we discuss, it is not only the substance over form, it is the form which leads to acceptance of substance. So, economic activities carried out by the foreign company will be going forward an important factor to determine, considering the longevity of contract, considering the remuneration model, considering the controls exercised by it. So holistic picture needs to be considered, given a due consideration for determining whether the foreign company has a business operations in India, or is it just a stewardship activities. And last, whether the attribution of profit to PE is settled or not in view of the larger bench decision in High Court, which is a part of the Supreme Court decision at a later part of the judgment. So whether the doctrine of merger would apply and the Supreme Court has upheld the entity level approach or not, that needs to be seen in the times to come. So this is from our side. So Prakashji, we are happy to take and discuss the views of Pannu sir, Sunil sir, and you on this decision.
Yes, sir. Thank you, Ashish ji, for your delivery, for your wonderful deliberation here. Now the, in fact, discussion starts here. You have given so much of the point that we should deliberate and learn from these points here. Before
Yes.
we, I think Sanjeev sir has raised his hand here. Before we hear Sanjeev sir, may I request Sunil Aggarwal sir to give something revenue perspective on this point here. Because most of the important point that he has raised, that this arrangement was made prior to the treaty coming into the force between India and UAE, and there was some other arrangement also. So please, yeah. Sanjeev sir, we will come back to you, sir. Just, yeah.
Thank you, Prakashji, and thank you all the participants. First of all, I would like to clear one basic thing. Prakashji said that I should present the revenues perspective. And those who know me, perhaps they know and they will say that I have been in the revenue service. Then I was for almost 15 years as a senior partner in AZB and Partners. We were working exclusively for private sector. Today, in one sector, that is income tax, I am the senior standing counsel for Delhi High Court, in Delhi High Court for income tax. But other matters like GST or ED or FERA and all those things, I do privately. What I am trying to convey, I always believe in a balanced approach, in a specific approach, in a law. So my view may not be misunderstood as a revenues view. I would share a really realistic view, which should stand the test of time and which should be helpful to the assessee and in all times, so that the affairs can be arranged accordingly and surprises are not thrown out at a subsequent stage. So friends, if you agree, and those who see me in the High Court, etc., I am the one who surrenders matters where I have no merit. But wherever I am merit, I take it to the logical end. So that is it. So just to be on the that I would say fairness side and clarity side. That is now, friends.
I stand corrected, sir. Sorry, sir.
No. This is just this is my introduction in my words. I
Yeah.
am not questioning what you introduced.
Yeah.
And all of you know me, so and I think most of them are common to IFA also. So I think this is just a anyway. Now, friends, Ashish ji has done a wonderful job of, I would say, having done anatomical dissection of the judgment. Not only the present body of the judgment, which has come from Supreme Court, the prior avatars of this position, that pre-1992, what was the position, and then treaty came in and all that. Friends, just permit me, I would rather give I would say, a holistic and a consistent view. Technicalities, we can come slightly later. So after, now we know that there are 5 authorities which have deliberated on this issue. So now we have the limited issue is whether the assessee, that is the UAE entity, had the permanent establishment in India. That was the, to my mind, shorn of all the unnecessary things. That is the core issue. Now, the court, Supreme Court in particular, as I was reading the judgment, I just noted down some points. that some kind of the evidence which they have relied upon, if I may say so, that they have taken note of, I have noted down 5 points. One, the long duration of the contract. That SOSA, it is 20 years or that such a long duration. Friends, am I clearly audible?
Yes, sir.
Yes,
Yeah.
sir.
Yes, sir. Yes, sir.
Now, point number 2, continued presence of employees of assessee in India. Point number 3, and I would underline this point, remuneration linked to the productivity of the managed hotel. Point number 4, and which I would need a confirmation from Ashish ji, the Supreme Court says that the UAE entity had control over the bank accounts of Indian entity.
Yes,
Is
sir.
it?
Yes,
So
this is
bank-
correct.
Okay. And then one more point they have noted, which I again need a confirmation factual. Employees of the UAE entity could be sent to the Indian entity without request of managed Indian entity.
Correct, sir.
Yes, sir.
So, to my mind, these are the, I would say, pieces of undisputed evidence, if I may say so, which the Supreme Court has considered, or rather, I would say, they have, as you know, in the law of evidence, that there is one is called evidence, and one is facts are proved, disproved, not proved. I would make that distinction. So this is the evidence. Now, on this evidence, whether the fact of PE in India is proved or not, that I will leave to the larger audience. Now, so now these are the evidences. I am not taking them as argument; they are evidences. Now, to my mind, the real issue before Honorable Supreme Court and maybe before all lower authorities was whether this SOSA is purely consultancy, or you can say advisory agreement between the UAE entity and the Indian entity, or it was evidence of day-to-day operational control of Indian entity by the UAE entity. To my mind, the Supreme Court had to draw the Lakshman Rekha between these two situations.
Correct, sir.
Assuming it was a purely consultancy advisory agreement, means some kind of a hands-off approach, and somebody, I think Ashish ji or Richa ji, or I think Diksha, sorry, Diksha.
Yes, yes.
Yes.
So she said that this is a now an example is there in the Delhi High Court judgment that a chartered accountant working in the place of the client, if he does
Right.
the auditing job or whatever job he has been given as a professional, then his mere presence will not make it a PE of the chartered accountant on the client's case, right? Friends, I am a practicing lawyer. I know the client approaches me with a brief. I am least bothered about his, I mean, if I may say so, that where is his office, I am concentrating on the brief, the problem he is facing, and what I can do to minimize, attenuate, or extinguish his problems. So what I do not participate or in his business. I do not integrate myself into his business. I do not ask him what is your turnover and profitability before I make up my mind to quote a fee. I am not concerned with his earnings. I am not. So an advisor or a consultant would charge for his own time, his own competence, the value of his time. It will not be having any linkage to the turnover or profitability of the client who approaches me. I mean,
Correct, sir.
all of us are professionals, so we can be very frank among each other. So we are not. Now, if I say, I mean, just I'm testing myself. If my client who approaches me, if his turnover is 100 crore, then I will charge X fee. If his turnover is 1000 crore, my fee will become 5x. If some poor client comes to me, I will say you can give me half x. और बिल्कुल ही गरीब आदमी आ गया तो चल तेरे लिए फ्री कर देता हूँ. लास्ट एस्पेक्ट आई ऑलवेज प्रैक्टिस कि गरीब है नहीं दे सकता है उसको फ्री करना ही है, वो तो हमारे एक प्रो बोनो का एक परसेंटेज होता है इन ए सेंस, बट बाकियों में हमको मतलब नहीं. तो नाउ दिस वाज द रियल आई वुड से challenge in the mind of the Supreme Court, and they had to decide now, or whether it was due to the operational control. Now, this decision has to be taken on the basis of evidence on record. And in this context, I will come back to my earlier point that, to my mind, remuneration based on and linked to the productivity of the Indian hotel, that perhaps has done a great influence in the mind of the judiciary to come to a conclusion that it was not a case of remote hands-off kind of advisory agreement. It was more of a day-to-day operational control. And this is commonsensical also. You see, let us say I am the Indian hotel. If I am managed remotely by somebody in UAE or in USA, and he is not visible to me, I will not be foolish enough to pay them a percentage of my earnings, my variable earnings. I would like to ensure that they ensure increase in my productivity, which then I share between myself and my advisor. Business always goes on the principle of mutual interest. In fact, and I think CA Saurabh is laughing, and I can understand. Now, what Trump, and please permit me only 30-second digression, what Trump is doing is impossible. Business cannot happen like this. It has to benefit him only, and it has to destroy all other countries. Even if he succeeds in all these agreements, within 30 days, America will be absolute zero, and other countries will also be absolute zero. So business can always happen. गुजरात में मैं रहा हूँ, बॉम्बे में बहुत रहा हूँ, पन्नू सर बॉम्बे में रहे हैं, हर जगह रहे होंगे, कि बिजनेस में अगर मैं 1 रुपया कमाता हूँ तो मैं सोचूंगा कि भाई, तो आपकी प्रकाश जी के साथ किया मैंने, 1 रुपया कमाया मैंने, ठीक है 50 पैसे आप रखो, 50 पैसे मैं रखता हूँ. अगर ये अंडरस्टैंडिंग नहीं होगी तो बिजनेस कभी हो ही नहीं सकता. बिजनेस में म्यूचुअलिटी होती है. म्यूचुअल सर, पन्नू सर, आई कैन सी हिज हेड. So that is a common sense thing. Nobody can exploit in business. It has to be mutually beneficial. So to my mind, just to instead of going into theory, because Diksha ji, you are Diksha ji, right? So and Ashish ji, you have dealt with the facts very clearly. I am just trying to summarize it, because ultimately some of us are advocates, some of Pannu Sahab and his colleagues will be the judges. So ultimately, what I am seeing is that evidence was sufficient in the mind of before the Supreme Court, and we cannot forget the fact. At the moment, I am setting aside that attribution versus global formulary apportionment. That point I will slightly later cover. I am on the PE aspect only. That once so we have to simply separate that this is one of remote controlled advisory, like the fee of a lawyer on a particular assignment, fixed fee, or it is a continuous involvement. On this basis, and then the employees were regularly there. Yes, I had noted that point, that the strict treaty test of 9, that presence of the employees is not being satisfied. But somehow the court has gone on the overall quality of the evidence. And we should not forget that here the findings are almost concurrent of 5 authorities. Means assessing officer, it was CIT pilot or DRP?
Yeah,
DRP.
DRP, and then ITAT, then Delhi High Court, and then Supreme Court. On this aspect, there has been a unanimity. So the higher court perhaps cannot invent a perversity when 4 lower courts, including the High Court, including the Honorable ITAT, which Pannu Sahib headed. Now, if these people have come to a view, which is a plausible view, which is not a impossible view,
Right.
I would say that these 5 factors which I initially listed, and remuneration linked to productivity, and the capacity of the UAE entity to send employees to the Indian entity without request of Indian entity. And who are those employees? Managing director, director finance, that kind of employees. It is not that ordinary workers to clean the hotel or to be a waiter. So these are the decision makers. So in my, I am not saying pro revenue, because I am today standing counsel, tomorrow I can resign and I will be on your side. In any case, I'm on your side on GST and all those things. So my view will not be affected by who my client is. I would rather help the client in giving the right advice, right representation, so that in future he is immune from unexpected shocks. That is what my approach will be. And to my mind, at least on these facts, the Supreme Court perhaps is right in affirming the view of Pannu Sahib. The tribe, he represents tribunal, and then High Court, and then Supreme Court. So, my friends, so I think that is on the factual aspect. Now, if you permit me, I would like to one more point which was raised: stewardship versus Morgan Stanley. Now, all
Yes,
of
sir.
you are experts. So I want to go straight to the point. In stewardship, the foreign entity was paying their employees. They were for the quality control of foreign entity. Means the Indian service provider should provide a quality which meets the standards of foreign company. And Indian entity was not paying for the stewards. Here, what is it? Is the contrary position. Indian entity is paying the profit linked fee. So basically, Indian entity is paying. So perhaps on factual aspects, Morgan Stanley stewardship and all those principles will not apply. That is my, I would say, honest understanding.
Yes,
And
sir.
then one more aspect on an overall view. And that is, in fact, I am happy that my younger colleagues here, they are very inventive, very hardworking, very vigilant. They have brought out very good facts. The point is that one way of looking at it is that, and we should do it as professionals, to find out points in favor of our client. That is a permissible, or that is the rather our approach. Our existence is because of our clients. So we have to do that. Now the point is that I noted that the treaty, background of the treaty. Now, treaty does not have FTS clause. All of us know. And this is not the only treaty like that. If I remember, Thailand also does not have a FTS clause. There is some other treaty also. You people are more expert than me on these aspects. So some 3-4 treaties I know, there are no FTS clause. So friends, to my mind, of course, I know with due respect to Pannu Sahib and tribunal and various high courts, that somehow the courts have taken a view that absence of FTS clause in the treaty means treaty overriding the domestic law. The law, in my humble view, a treaty has to expressly override the Income Tax Act, then only it becomes operative. When treaty have that clause, then it cannot override. So to my mind, that argument, if all of you are sharp enough, that when the Income Tax Act provides 917 specific definition of the FTS, treaty is silent. Let the treaty override. The US treaty overrides partly. Singapore treaty overrides partly. No cavil, no quarrel. But here the treaty is silent. So Income Tax Act will override the treaty because treaty doesn't say anything. There must be express conflict between the treaty and the act. Then only treaty operates. So to my mind, maybe we are, and I would highlight one point. We have to, this is an approach. We have to see what are the positive activities which the assessee is doing, positive affirmative activities, means UAE entity is doing in India. That is one way of looking at it. And then, so that I have already listed. Now, one point which my younger friend said, and this is very relevant, that burden of proving the permanent establishment is on revenue. Nobody can cavil and quarrel at that. But friends, you should be knowing, and I just, with permission of Pannu Saab, I would like to just take half a minute, that strict rules of Evidence Act do not apply to taxation, that we know. But strict formal rules, principles are always there, in the sense that what the treaty says, business income is not taxable unless the assessee is carrying on business in having a P in India. Now the assessing officer's role, section 101 of the Evidence Act, that simply says that, okay, revenue has to provide some prima facie evidence. And please permit me to just slightly dilate it. Now, what is the prima facie evidence? All of you friends know that no non-resident, at least I do not remember being the first additional director, International Taxation in Bombay, when this division was created in 2001. I have never seen any foreign entity in India who does not have a 100% subsidiary in India. I have never seen. I am not talking of some fly-by-night operators. I am talking of those who are regularly doing business in India. Without 100% subsidiary, they are not. Now, all of you know, 100% subsidiary will be economically dependent on the foreign entity, because entire source of revenue is because of the activities of foreign entity. All of you know, treaty has a clause that an agent, I mean, I am not going into that agent or independent, whatever, but a person whose 100% earning is dependent on the parent, he cannot be independent. That is what the treaty says. Then you have to do that transfer pricing, fair market and all that. That is a different thing. But prima facie, there is some kind of a dependent agent. I'm just giving an example. Here we have employees. I agree with all of you that maybe strict literal test of the presence in India is not satisfied, maybe. But what the court has said, those employees are coming and going. So continuity is more important in the context of the business rather than one factor here and there. So the point is that revenue has to prove given a prima facie evidence, you have 100% subsidiary, your employees are coming, you are doing your what we call it, remuneration is linked to the productivity in India. These are prima facie factors which show that you are having at least a business connection. At least a business connection. No Indian will be paying you for your variable fee. Then the assessee has to say no. So revenue's burden is discharged here. Now the assessee has to, because the facts are within the special knowledge of the assessee. So now the facts which are within the special knowledge of the assessee has to say that he is not there for A, B, C, D reasons. Just this thing, that the burden of proof has to be discharged in a flexible manner. It is not inflexible. So friends, this is the way, I mean, I would like to summarize it. And now I would like to just give one more minute to that part, that larger bench decision of the Delhi High Court, attribution versus this, what we call it, global formulary apportionment. Entity level, what you are saying is,
Yes.
in the international, all of you are experts. This is global formulary apportionment, that entity level, which is prescribed in rule number 10 of income tax rules, item number 2. First item is, now all of you know that in article 7 of the treaty, all treaties, the word used is attribution. Attribution means that Indian P, let us say American P, UAE P, Japan P, whatever, every P will be treated as functional independent entity, functional, and the profit of its activities will be attached to it. That is attribution. Global formulary apportionment, that is rule 10(2), is simply saying you look at the entire entity, have the global profitability and allocate it in a mechanical manner. All of you are arguing in the courts that AO has done it mechanically, AO has done mechanically, the order should be quashed. So that is the mechanical approach. So,
Right.
and treaty does not approve anywhere this global formulary approach. It is there only in the last clauses, where it says that when it is impossible to apply attribution, then some kind of a consistent method has to be applied. That is in the last. So, with the permission of the honorable members, and I think this is my take on the entire judgment, and in some I would say that at least on the evidence, because ultimately the principles of PE and business connection are as old as hills. Everybody knows. Only question is applying them to the given set of facts. Nothing is permanent here. Tomorrow there may be a case. Maybe this assessee will go again for a different year. Maybe the facts are different. It may be that we will not be. So there's nothing permanent. Nothing is permanent here.
Yes, sir.
So that is my take. Thank you for giving me a patient opportunity to express myself.
Yeah, before we come to Pannu sir here, with the permission of Pannu sir, may I ask Sanjeev sir, who is raised his hand, to speak something on that part here, sir? If Pannu sir permits on the.
Yes, please. Sanjeev is an authority on the subject. Please.
No, thank you, sir. I hope I'm audible, right?
Yes.
Okay. Well, I'll just keep it very brief. Even I would like to hear you, Mr. Pannu. Just a couple of points. One is when you look at the tribunal judgment, sir, the SSC actually raised a point before the tribunal on attribution. And the tribunal in the order has given the SSC a liberty to go back to the assessing officer when the profits attribution is to be done. Now, if I look at the Motorola's judgment, 2005 special bench, there we looked at the worldwide profits because the PE taxation had just started in 96, 97 when the first years came up. And everyone said, okay, look at the worldwide profits, attribute to the sales in India and then attribute a portion to it on account of the activities to be carried out in India. So the profits had to be attributed. Point number one. Two, I think Hayat made a point to say that even if you look at the entity approach, I'll have losses and I should be permitted to put forward my factual information on the taxability because even if you say tax the PE, I'll still have losses. Now, to the best of my knowledge from a distance, I don't think an appeal effect order has been passed as yet. And if it hasn't passed, I don't know the fate of it because that itself will be a separate litigation. You see, even if the PE is held, the tribunal had given this direction. Revenue has not challenged it before the High Court. To that extent, the order of the tribunal is final because it has not been challenged. Now, whatever the AO does in the appeal effect order, that again may get into a separate kind of a litigation. That is one point which I wanted to bring out on the attribution point because revenue has not gone into the appeal before the High Court. So that part of the tribunal order is a final order. That's point number one. And I think, sir, it is para 60, if I remember correctly, of the tribunal order. I don't have it before me, but it is para 60, where the tribunal said that the SSC be given an opportunity of submitting the working of the apportionment of revenue, losses, etc. on a financial year basis, etc., etc. That's point number one I thought I'll just bring out. And the second point is, then when the High Court passed the order which went into an appeal before the Supreme Court, by then the full bench order had not come. So there was no occasion for Hayat to argue before the Supreme Court on the attribution of profits, the entity approach or the what approach to follow. Because by that time, the Nokia order was final. And Nokia order was emanating from the Motorola Inc., Motorola Ericsson Nokia's order. The full bench order was not passed by then. So the Supreme Court had no reason to go into the findings because the findings were not before the Supreme Court. Hayat had not even challenged it. So the point I'm trying to make is on the attribution, I think the final word of the Supreme Court has not come. They may have made an observation, but the observation also had to be read in some context. The arbiter has to read in some context. It is the ratio which applies. All of us know that. That's point number two. And three, I think Mr. Aggarwal already made a point on Morgan Stanley. Morgan Stanley was a different case altogether. There was a back office here. There was the stewardship activity. The stewardship, whether those people were paid by the US entity or India entity was not the question. The question was stewardship activity. Here you were carrying out certain activities in India, so that, like the E-fund, has no application here. That was again a back office. So I think on that point there is no dispute. I thought let's just raise a couple of points just to add to what has been discussed till now. And thank you very much, Prakashji, and thank you, Pannu Saab. Back to you, sir.
With Pannuji's permission, sir, can I address Sanjeevji's point?
Oh, why not? Of course, yes.
Sanjeevji, you have made a very valid point. So, I mean, and that I was not aware, in fact, that that before the tribunal, the assessee made certain arguments, and on the attribution or global formulary apportionment, as I say, the entity level approach, where the department accepted it, that has become final. So, but you are saying that even today the AO has not passed the ultimate appeal effect order.
I'm not aware about it, sir. It is not in the public domain as far as I'm concerned. I'm not aware about it. Maybe Ashish or Diksha or anybody else can throw some light. I have not seen, so that litigation is not in public domain. That's my only submission.
So I think
Yes.
what I'm trying to say that first of all, attribution will be a question of largely a fact. Therefore, High Court or Supreme Court or
May not.
will not go into that. They will simply say, so long as some reasonable basis has been adopted, it will be immune from disturbance. That is one. I think your bigger point is, which I take it, and that's why I requested for permission from Pannuji, that what you are saying is that if it is a case of global losses of hair, and that principle and that argument is accepted, then despite Supreme Court and Delhi High Court being against HIR, ultimately in the net analysis, they might not be required to pay any tax.
Correct.
That is your point. And if attribution is applied, then some tax may be required to be paid. I think so that point is well taken, but I mean, of course, I mean, if somebody in the participants or maybe if anybody can sort of enlighten us, what is the factual position on ground at the AO level?
No, I'll just respond to one point, Pannu Saab. You know what happened in the case of another company, which is again a public knowledge, is that you have the CSR company, CRS, Computer Reservation, the Galileos of the world.
Yeah.
Right? You would have remembered the order, maybe one of the orders you had also passed, where we had, as an assessee, a P was held in our case by the tribunal, confirmed, but on attribution, the CRS company was paying a higher amount to the entity in India. Now, if you look at the payment being done, which is much higher than the attribution of profits, ultimately there is nothing left to be taxable in India. Now, the assessee obviously did not file an appeal, even if the PE was held. When the matter went to the High Court and Supreme Court, the caveat from our side was to say that if it is held that we have a PE in India and the attribution is disturbed, then we will argue the case that there is no PE. To cut the long story short, Supreme Court said, we are accepting the High Court order to say that there is an attribution and you are making a higher payment to the Indian entity. So there is nothing left to taxable. And the rest of the points are academic. We are not even going into it.
Absolutely.
Now, here also, highest case is whether you look at the worldwide approach or the entity approach of taxing in India. They're saying taxing in India also will have a loss. Because worldwide there is a loss of some 10 million dirhams or something, which they're saying in that order. But that is, again, I think a factual point which still has to be looked into. What happens is, I don't know, maybe Ashish or Diksha has some information.
No, I think you see,
I'll stop here, sir. Yes.
Probably we all are discussing on the basis of whatever is known to us.
Yeah, absolutely.
So as I can understand from whatever papers I have vis-a-vis the attribution and the computation part of it, what the AO did at the first stage was that he took 25% receipts as the profit taxable in India.
Yes, sir.
Right. Effectively 10% tax.
Which was what was the effect, whatever the effective rate may be. Now, ultimately, what the tribunal did at that point was to send it back to the AO for that matter.
Yes, sir.
So the gross will not work. You have to go to the net margins.
Right.
Now, surprisingly, one of the and that's what the issue which went to the larger bench of the Delhi High Court. That was the question 4, which they have the Supreme Court has reproduced. Is Article 7(1) DTA at all applicable to the applicant, having regard to the fact that it has incurred losses in the relevant financial years? So this question has overtones and clearly of computational requirement, the basis of computation and attribution, whatever it may be.
Yes.
So this is what they have said in the closing of their order when they refer to the larger bench of the Delhi High Court having said that notwithstanding your global, as what Mr. Aggarwal explained very aptly, that whatever be your global this thing, but if at all there is any attributable to the PE here, you can still be going in for a separate computation. Let me put it like that. So now, unless we see what has the AO done, as you rightly put it, unless we could be a separate streak of litigation which is there at certain stage, which we all do not know at this moment.
That's right, sir. That was the only point I thought I'll fix.
And so far as Galileo, so far you rightly said that Galileo, I think that was Galileo's case which you're referring to. There anyway, probably Supreme Court felt that, look, on the basis of factual aspect, if there is there is something which to the Indian exchequer tax net which has come, which is higher than the price of the ALP, then any case, whether you have but it is immaterial, you anyway should not be, so don't get into that question. You close the matter.
That's right.
So, of course. So therefore, this aspect to that extent is may not have been open. Just it is open because we do not have the complete facts, perhaps.
That's right.
For all you know, the Hayat and the revenue would have settled already by now in the computational real effect. We do not know that. So Mr. Aggarwal to that extent is right. Unless we know that, we would not be. But then the broad principle, as you know, Diksha probably, or I think Ashish raised, that how will it be taken as a precedent now on this aspect? No,
Yes.
that is something which we will see whether it is to happen or not, depend on how the factual position of the litigation is. But that's one aspect. But anyway, my coming back to the entire judgment as such, Mr. Aggarwal rightly brought out that there is nobody this side or that side, and that too after the law has come from the Supreme Court. And because obviously the people who stand for the department in the courts, made in the tribunals, made in the Supreme Court, they also have to be pro-law ultimately, not necessarily pro the department or pro the assessee. Ultimately, whether we stand for the assessees or for the tax department, ultimately we have to assist to see to it that jurisprudence that is brought out by the court is well reasoned and well founded. And as Mr. Aggarwal said, you should stand the test of the time also. So,
Right.
Having said that, now actually Mr. Aggarwal has brought it out very well, and the preface by Ashish and Diksha. You see, I have one or two points to ponder over. This judgment, as rightly said by Ashish and so also Mr. Aggarwal, that it is on facts. How the authorities have found the facts. No, in that we could have some kind of imponderables, which to my mind, which they seem to, because I am not aware of in the first-hand knowledge of facts. You see, para 16 of the judgment brings out those 5 points, which exactly what has prevailed, what Mr. Aggarwal brought out. That if you have the power to appoint and supervise a general manager. No, general manager, in one of the places they said that I could observe the general manager reports to this UAE company. Now, the implementing human resource and procurement policies, implementation of those policies. Controlling the pricing. So therefore, you control what your revenues are going to be. That's what they're saying. The control, of course, control the brand and the marketing is one aspect, which can still pass off as something which is advisory. But to say that we control the pricing also, no, that doesn't leave you with much leeway. And then managing the operational bank accounts. Assigning personnel to the hotel without requiring the owner's consent. Now, you see, all these things lead to one fundamental point in my mind. And that's why I had at the very beginning also, interfered to say that, Ashish, why don't you bring out the entire original, the facts on the top. You see, the Hayat Corporation USA has 2 subsidiaries. One is the Hayat UAE, which is the assessee, and Hayat India. As per the factual aspect, it is Hayat India which has the operation agreement with the Indian AHL, Asian Hotels. It is only an oversight agreement which the UAE company has. Now, if UAE company is found to be doing all this, as what Mr. Aggarwal brought out, what para 16 of the Supreme Court says, then what is that operational agreement with the Indian company here, the subsidiary of the US? What are they doing in that sense? If general manager reports to the UAE, if they control the operation of the bank accounts, If they can appoint people and send it and depute, so then what is that operational control and operational agreement with the Indian yacht? I don't understand. And this judgment, High Court also, Tribunal also, and so also Supreme Court now, doesn't say that we have taken an overall view of the matter as was done in the formulas case. There they looked at all the agreements. They looked at the original agreement 2007, substituted by the other agreement 2011. They also saw, look, there is a FIA, which is the body which runs, which controls and everything. They gave out commercial rights to one concern. That concern had an agreement with JP for promoting, staging, and hosting. And thereafter, the JP had dilated those agreements to 2-3 other people of hosting and everything, which were again controlled by the same outside company. So they brought out the entire conspectus of different entities in the same group. And therefore, they said, look, it is not a case, as Philip Baker has said in his commentary, it is not a case where you are trading with the country. It's a case where you're trading in the country. Now, the point to be, and the only point which I feel is, so far as stewardship is concerned, Ashish, they have not argued at any stage for that matter.
Yes.
I don't see this point coming in. And surprisingly, if you look at one of the tests to see the place of disposal, now at disposal would also mean, and that's what they have also said so in so many words, that they have quoted the OECD, and they have concurred with it also, Indian. So the POB will usually exist only where the taxpayer is free to use the POB, the place of business, one, at any time of his own choice. Second, for work relating to more than one customer, and for his internal administrative and bureaucratic work. Now, my point is, the entire emphasis of the entire case has been that the UAE company is actually running the hotel. That's their case, bottom line.
Yes, sir.
But is that enough? The example of chartered accountant was taken. If CA goes to a client's office, he's assigned the duty of to do his auditing. He does the auditing. Of course, it doesn't create a PE, but if in that premises he also advises Sanjeev, he advises Ashish also, with affairs, he advises Mr. Pannu also, or Mr. Garg also, Mr. Aggarwal also, then obviously it can be a place where he is using it for his own more than one customer and his own bureaucratic work. It will be a PE for that matter. So the entire emphasis in this judgment has been on what they are doing for the hotel. And at the beginning, I read in the judgment that they have another hotel with whom they have oversight, which is in Mumbai or Goa.
Mumbai.
That's a separate agreement.
Separate agreement.
That's a separate agreement. So there is no finding to that effect that even the Goa is managed like this, the Goa is also managed like the Goa, or the Mumbai is also managed. So therefore, that aspect to my mind. But having said so, the Supreme Court was conscious of this, and therefore, to that extent, they have written para 18. That's what I would like to read out now. The argument that the absence of a specific clause in the SOSA permitting the conduct of business on hotel premises negates the existence of PE is also without merit. Now, why? Now, that's what this is. As held in Formula 1, the test is not whether a formal right of use is granted, but whether in substance the premises were at the disposal of the enterprise and were used for conducting its core business functions. So, the point is, now, rejection of that argument is fine, but none of the orders below have built up that foundation of the facts. I would not say that it is on the inadequacy on the part of the courts, but perhaps there is some inadequacy somewhere to cull out and bring out the entire fact, which is the duty, of course, of the assessee for that matter. Mr. Aggarwal is right in saying It is only the initial burden which the revenue has to perform, and which the AO in this case has done it appropriately. And that's what Supreme Court has noted also. So to that extent, that burden is discharged, but there is nothing brought out what was there in the agreement with the Indian Hayat company, which is the operational agreement. Nothing to.
Right.
And if it was the case of overlapping of functions, was it so? It can't be that oversight also will have a control over the GM, and so will the Indian operational company also will have. These are questions which arise in my mind. I am not aware of the facts as such directly, but these are a few things. But yes, so far as the principles are concerned, as Mr. Aggarwal rightly pointed out, and so also Ashish, that the principle as laid out, there are no new principles brought out so far as to decide what is a PE. But certainly, yes, it all has been brought out as the factually how the contours have worked. They have again said so after Formula 1 that it is not necessarily only the legal substance, it is up to the substance, not the legal form precisely. What you actually do. But in Formula 1, they looked at all the multiple agreements within the group and came to the finding, and look, this is how the test is satisfied. In this case, it is confined to the UAE SOSA, but it has overtones of something which is an operational agreement. To my mind, I don't know, that's something which is imponderable because we do not have those facts with us. And neither any of us is from the side of the SECI to know as to what is the actual position. Because, you see, the Supreme Court was conscious of that principle. That is why, again, in para 20, they say, in the present case, the hotel staff was the situs of the applicant's primary business operations. So, but then, what were the objects of the UAE subsidiary? They were only giving them consultancy and advisory. In fact, the Hayat India and AHL, the agreement gave Hayat India the responsibility for day-to-day management and technical assistance, not to SOSA. How have we reconciled that? Probably nobody seems to have brought out that thing. Hey, it is for the parties to bring out. And thereafter, the courts can have a view on it. Otherwise, the court will go with the formulation of the facts, which are anyway, which is emerging from the orders. And as Mr. Aggarwal rightly said, there are 4 orders now before you. How can the Supreme Court then suddenly say no, this factually? Or only on the strength of what is argued on the basis of the agreement, but they have said so. That is why they say so. And that is what they said, it is in line with its commercial interests. So, this is where the whole thing, and the last para is very, very, effectively putting beyond doubt. Appellant's role was not confined to high-level decision-making, but extended to substantive operational control and implementation. The appellant's ability to enforce compliance, oversee operations, and derive profit-linked fees from the hotel's earning demonstrates a clear and continuous commercial nexus and control with the hotel's core functions. This nexus satisfies the condition of 5.1. So far as that point of, you see, that argument being made that, look, the people were coming in, but nobody stayed for X number of periods, so therefore, no. That is for a different test. It is not case of 5.1. For 5.1, what they inferred was that people were coming at different points of time, which ensured continuity of operations and control. To that extent, they have functionally understood it like this. And there's nothing wrong in that.
Correct.
To my mind, I could be somehow misplaced because we don't have the entire thing. But the entire judgment turns on its own facts as found on record. So, but yes, it also is an indicator that what is important is at the time of initial understanding the roles of different parties to a contract is that they should not only be put in such a manner that it truly depicts what is there on the ground also. And if there is a scope of mix-up, if it is you have multiple agreements, if there is a case of mix-up, then you are up against a definite argument from other side. Look, these are agreements which are, connected in one way or other with the objective and the goal of trading in the country and not only trading with the country. See, that is the bottom line of the whole thing which is there. And other thing which is, I think these are the few points which have been brought out that should, I think, effectively. What do you think, Mr. Aggarwal? I think anything else that we need to cover in understanding the and getting the benefit of the judgment and understanding what could have, might have done, not happened, and could have happened also otherwise.
Sir, the Supreme Court has coined the three terms: stability, productivity, and dependence.
Correct. So they have used from Formula One, where
Yes.
I've said so. And see, what they are saying is it's a very long duration, a period of 20 years of this thing. But in the case of Formula One, that was pleaded that look, the race is there only for three days, only 4 days in a year, and that's the only time when the foreign company comes in and takes over. So therefore, you can't say there is a continuity. But what they said was that look, it's kind of a, you have to look at what the business mechanics are. The races take place all the 12 months, but they are taken different places. So the foreign company which is doing in all this comes to India for those 3 days, controls everything, conducts everything its own manner, under its control, and in its manner, how it wants it. So therefore, and the agreement is for 5 to 10 years, 15 years. So obviously, they run it as a continuity. So you have to look at it vis-a-vis how what are the mechanics of business. Here also, what they're saying is one employee may not have been here for X number of period, which is the threshold limit in the DTAAA, but that's for the other test of PE, service PE perhaps. But here they said that different people were coming in, but there was a continuity of those people being deputed. The mind of the UA company being here on a continuous basis, maybe in different form. Yet they found it to be a continuous one. And yes, there is a commercial interest in the sense that it linked to your business. And dependence, of course, is there. That was the third point which is seen. The HAYAT, the trade license agreement is there of the group with the Indian AHL. So there is a dependence. When they are controlling your bank account, financial controls, there is a dependence. So therefore, it was a difficult case for the SEC to come out once such kind of facts are there. What, Prakash, anything? Should we go to the next judgment?
Sir, because we have many questions that is there in the and many participants want to raise some questions here, and it is very good that we are deliberating this judgment thoroughly here. And it is very much learning for all of us participants that we are trying to.
Okay, so we can discuss those questions one by one. So you can put it, or if you can put it across, or anyone can put it across, we can.
Yes. So Diksha ma'am, you have raised your hand. What is your issue here in this case? You have spoken so much.
That is why she would have a question.
Well, Pannu sir has highlighted one point that so in the SOSA, Hayat UAE was having so much of control, like the pricing decisions and operational control over the bank account. So you have an apprehension what Indian hotel or the Hayat India was doing. So the only apprehension is towards the HOSA agreement, which was there, but that was not discussed in detail.
Correct.
So it was never brought to the notice of all the honorable ITAT, High Court, Supreme Court, what that in Hayat India was doing. So maybe if there was a distinguishment between both the agreement, then the picture might be different. That is something in apprehension only. But yes, that might be of satisfaction that this is what Indian entity is doing and this is what UAE. And then we can say that, okay, this is the operational control which UAE was having and Indian entity was not having. So this might be a distinguishing factor.
And one more point just to add here before we, with your permission, sir. even they have not brought out what is the role of the promoter entity. So it's not you are running a hotel in India, it's not the operations and management, it is more than that. So they have the legal ownership and title of the hotel in India. They are doing so many activities, including repair, renovation, so many activities which a owner has to do. So the role of the owner has not clearly brought out before the revenue authorities. So that might create a difference.
We don't know, Ashish, because you see, in para 12 of the Supreme Court, they have, I think they have also very, I think they were conscious and they wanted to make it a very lucid order because obviously it was going against the SSC, so they have been very cautious. That is why if you read para 12, 12.1 and 12.2 of the judgment, and I'll just read one sentence from there where they have analyzed the agreement, so of course the oversight agreement. And they say under section 2, this is in para 12.2, under section 2, that is referring to the agreement there, the SSC is vested with the complete control. SSC is UAE. The UAE is vested with complete control and discretion in formulating and establishing the strategic plan for all aspects of hotel operations, including branding, marketing, product development, and daily operations. So I wonder, what is that agreement of operational agreement with the other Indian yacht? See, these things raise questions as to, so therefore they have gone by what is there before them.
So maybe there was nothing which is SSC additionally brought on record.
May not have been, and it is not necessary that, in fact, it is not at all advisable to do that at the tribunal or high court. It has to be AO, the first point.
Yes.
You have to put your best foot forward for facts at the nascent stage, AOs. Because when Supreme Court says the initial onus is on AO, so you have to burden him to make it even more onerous for him. See, it is at that stage you have to put everything. So,
Yes.
अब इतना दूर तो नहीं आए और सुप्रीम कोर्ट ऐसा लिख रहा है, where is the that way?
I think, sir, if you permit me,
Yes,
just
sir.
to address Diksha's curiosity, perhaps, and she's a baniya, I mean, permit me to say that. So her intellect will be working.
Coming from
I
one to
think-
other, no issues.
Sir, what she is perhaps saying, and Diksha, please correct me if I have understood your mind correctly. What you are saying, if HOSA is also considered properly, then HOSA would also be basically working for SOSA, means for the UAE entity, that is a subsidiary of UAE or common parent. So if HOSA, if the Indian entity has paid some tax, that should be available as a set-off against the PE of UAE entity. That is your case?
नहीं, ये तो
yes.
आपने वैसे अग्रवाल साहब सही बात है, आपने बिल्कुल, ये तो आपने पंचायत भी कर दी साथ में. I mean, you took a baniya. I think that was a good cover you took. But you've done a panchayat also. Arey Baba, HOSA is India, Hat India is a subsidiary of USA. UA is also subsidiary of USA. लेकिन वो बेचारे ऐसा थोड़ा ना कि आप you are going to do a कि दिखाइए कौन कितनी प्लेट्स है, इकट्ठी करिए प्लेट अपना बहुत. Ultimately, तो है ही no. No, I appreciate what you have in mind, but then I think we have to go by what the judgment before us is, and also, in fact, I hats off to Ashish and Diksha both. They have brought out the orders of the lower authorities, which brings us and shows us as to on what basis the litigation has progressed. And I think as fellow professionals and the people and the students of tax law, I think the lesson we must learn is that we must be clear on our facts right from day one, even at the level of the setting authority. We should know as to what is our client doing. If it's the stage of assessment, we must put everything across. And if we are at the stage of planning, we are at the stage of structuring, then we must know the relevant criteria. We all know now by now the principles and the rules into how a PE is fashioned. We must all understand how a business connection is or can be deduced, so that we structure and ensure the functioning of the transactions also in the same manner. I think this is something which we need to understand from this judgment. और क्या बताते हैं मिस्टर अग्रवाल साहब, आप तो दोनों तरफ हैं, आप बताइए.
I think
Sir, sorry, the permission, that's
Richa ma'am
why.
has raised her hand.
Yeah.
Richa ma'am,
Sir,
you.
yes, sir. Sir, I just want to ask if you can throw some light base of this judgment, the impact of this judgment on GCCs operating in India. Because how the foreign companies, they have the full control over the IT, the HR, the recruitment, and there are people sitting in India and working for the foreign company. So what can be the impact of this judgment on GCCs?
You see, they, I mean, frankly, GCCs, I mean, it will not have a very, you know, a standard template kind of a thing. So one has to see as to what is the role. So ultimately, if they were to assess a candidate and say, we have assessed these candidates, now you see all 5 are fine, you select one of them, then. So therefore, everything which is so obviously, if all those things correspond to, and they do, and you tick all the boxes as what is before the Supreme Court, then answer is obvious in that sense. So each agreement will have to be seen and understood, even in GCs also, whose responsibility it is ultimately. What is how much is the hands-off approach, and then you must understand that to get a place of business for the purposes of through which the business is carried out, you have to clearly find out what is the foreign entity's business,
Yes.
and then say as to that a place is being used, as the example of CA was taken up by Ashish. But then he's only executing a project in that sense of his client. To that extent, it cannot be attributable as PE.
Right.
So वो थोड़ा ये सब चीजें you have to, I mean, it'll have to be, it may not be right for us to answer it in this manner. But yes, this is a good indicator and a good benchmarks to look at the agreements which you may come across with even the GCC businesses.
Right. Thank you, sir.
Aggarwal sir, I wanted to say something.
Yes.
I have already said I was addressing the mind of Diksha.
Okay.
May I just intervene on a very small thing?
Yes.
As in the back of the good presentation done by Ashish and Diksha and very well elucidated by Mr. Aggarwal and now by Mr. Pannu, and with the intervention of Sanjeev also. I was personally, I was curious to know what is the role of industry norms in this type of disputes. Means in hotels, for example, Diksha was referring to cases where this 20-year thing is a norm. Without that, the brand thing doesn't get properly imbibed in India. So that is a norm in hotel. There could be something else in other industries also. For example, these days we are having under the Make in India thing, manufacture of iPhones in India by Foxconn. That's a very specialized thing with even 1% of deviation from the quality which people attribute iPhone with. If we have that because it is made in India, that will be just damaging to the business. It must be very much like the normal iPhone that we are used to using. Number one. Tomorrow there will be has been permission already granted for this semiconductor manufacturing, semiconductor chips manufacturing. All these are very, very high profile, high technical intensive, high management intensive, where people will come down from the foreign countries to buy it and handle in India. So is this judgment to be a reckoner for the type of tax consequences that will be faced by these people who are trying to come to India under Make in India and other things? Or I mean, how they should, or should they build in that if we do this, it's Make in India, but if we do this, we must build in a high P risk. What is the view of the learned speakers, Mr. Aggarwal, Mr. Pannu over here?
Sir, if you permit me, Pannu sir.
Yes.
Sanjeev, Saurabh sorry. I think you said in the beginning, the risk dispute. I don't think, as a friendly manner I'm saying, payment of tax will be a dispute or risk. This is when you are doing business and you are earning profit. So tax is a necessary, all of us pay tax, and we don't consider it as a dispute. So, of course, I'm just trying to give a direction shift. That you see, just आपका ये point था ना कि that a new company when it enters India, it has to handhold, it has to build up some kind of capacity in India. I think all of you must be knowing, you are so expert. There is a Delhi High Court judgment called Centrica India Overseas. 2014 का जजमेंट है, 364 ITRS किसी में है, वो आप प्रकाश जी को मैं सर्कुलेट कर दूंगा, आप उसको देखिए जरा. मैं खाली इसलिए बोल रहा हूँ कि वी आर इन एकेडमिक सेशन. एकेडमिक मतलब वी आर होनिंग आवर स्किल्स एंड दीज स्किल्स विल बी यूज्ड फॉर द बेनिफिट ऑफ आवर क्लाइंट्स. So at this stage, I am not client specific, I am participant specific, toning the capability of the participant so that they can be better representative of the client. And see that. In that case, what was the case? I mean, Sir Pannu sir, if you permit me, it will take 2 minutes.
Yeah.
Because
so that involved deployment of employees and what was so ultimately आप बताइए उनको बिल्कुल.
हाँ सर, नहीं मैं इसलिए बता रहा हूँ उसके फैक्ट्स बड़े अजीब से थे.
Yes.
बहुत अजीब क्या है? We are talking of FTS, royalty, make available, technology transfer, technical know-how, ये सब की बात करते रहते हैं हम. रियल में वहाँ क्या था? The main parent company was billing the customers in UK monthly बिजली का बिल, monthly गैस का बिल. हमारे यहाँ जैसे BSCS का बिल आता है हर महीने बिजली का बिल, उस टाइप का बिल रेज करती थी वो कंपनी वहां पर यूके में, फॉर द कस्टमर्स ऑफ यूके, लंदन में, ग्लासगो में, बेलफास्ट में. नाउ दैट कंपनी आउटसोर्स्ड दैट एक्टिविटी टू इट्स इंडियन सब्सिडियरी विच वाज कॉल्ड सेंट्रिका इंडिया ओवरसीज प्राइवेट लिमिटेड. नाउ सेंट्रिका, उनका लॉजिक ये था कि इफ दोज बिल्स आर रेज्ड एंड प्रोसेस्ड एंड कलेक्टेड इन यूके दैट इज मोर कॉस्टली. इन इंडिया द सेम वर्क विल बी डन एट लेट अस से 1/3 कॉस्ट. इंडियन कंपनी आ गई. Now, Indian company in the initial stages, I think 5-year agreement was there. The MD, the finance director, and all those things like this, HOSA and SOSA, they were the employees of the foreign company and on the board of Indian company. Indian company was doing the back office operations in the sense it was raising the same bills which the UK parent would have been raising on the customers in England. Now it was found to be that Indian company the staff of Indian company will be trained to provide quality service of monthly consumers of electricity in London. I do not understand, I have not yet even today understood what is the quality service in raising a monthly bill of electricity, which all of us get every day, every month. But for that also, they created an Indian subsidiary and they sent their MD, finance director, for 3-5 years, and they were to train the staff of the Indian entity. Those secondaries would do that. After that, they will go away. This activity was held to be the transmission of soft skills by the foreign secondaries to the employees of the Indian company who would have been Indians for future. And this was held to be the make available clause was held to be satisfied of soft skills. Well, I mean, and they relied upon a AAR ruling, which is a very famous one, inter-track testing करके एक ruling है AAR की 2007 वगैरह की है, where they have given this aspect that we have to be practical, we have to be common. क्योंकि businessman common sensical होता है, businessman physical scientist नहीं होता है. So we have to common sensical कि बिजनेसमैन ने ठीक लगा कर दिया. उसने एग्जांपल दिया है कि एक डॉक्टर, व्हेन ए डॉक्टर ट्रीट्स ए पेशेंट, द पेशेंट डज नॉट बिकम ए डॉक्टर, सो मेक अवेलेबल टेस्ट इज नॉट सेटिस्फाइड. बट व्हेन ए डॉक्टर टीचेस, सीनियर डॉक्टर टीचेस ए मेडिकल स्टूडेंट हाउ टू डायग्नोज ए पेशेंट, व्हाट इज द ट्रीटमेंट यू विल प्रिस्क्राइब, देन द ट्रांसमिशन ऑफ knowledge happens. Make available satisfied.
Aggarwal sir, sorry for disturbance. We have Sanjeev sir is waiting to counter something on the Centrica. So Sanjeev sir,
please. I am just done. My point was that sometimes these things happen.
And we know that we are all running out of time here. Sanjeev sir, your
please. Sorry Sanjeev ji to keep you waiting.
I'll give you a perspective because I have argued this case before Delhi IIT post Centrica, You see, another thing
Okay.
is Centrica went to Supreme Court. SLP was dismissed in limine. So as
Okay.
far as Centrica is concerned, the case was shut and closed, right? Because
Hmm.
it was their case which went to Supreme Court. You see, I think the basic thing which went on the judge's mind was that there was those employees who were seconded to India had a lien on the job while going back. That was one important point which weighed in the minds of the judges, because this issue was debated at length in a number of forums post that. There are a number of tribunal judgments before Centrica to say there is no permanent establishment, there is no PE, it is not FTS, etc., etc. Now, as Mr. Pannu said, you see, the judges have a department counsel and a assessees counsel to explain the facts, bring out the case laws, bring out the precedents, etc. And the judges will apply their mind to it. Post that, the judge himself has said in one of these seminars which I attended with one of my other friends, he said these points which you are raising today were not raised before us in the High Court. Now, if they were raised before us in the High Court, the judgment could have been different. Obviously, he did not say would have been different, could have been different, because you can't say there is a Delhi High Court judgment. The point which I wanted to bring out was that there are certain points, and in fact, I wrote an article on this in our CA journal post Centrica, bringing out what was not discussed before the High Court. And if they were debated, the judgment could have been different. With due respect, there's a Delhi High Court. In Delhi, we had to follow it. But the point which I had tried to raise was, should I go to High Court if the case is different and I argue on different facts? And he said, well, why not? It may go to a larger bench if the judges don't agree with the previous judge or previous bench. But yes, till such time it is distinguished, differentiated, maybe a larger bench can look at it. And Mr. Pannu, there's one more point on
I think
Saurav's
that
point. Sorry,
even I
go
think
ahead.
there's a contrary Karnataka High Court also which came.
Yeah, absolutely.
So, I mean,
So
what
many,
Mr.
so many,
Aggarwal,
yeah.
what
many
Mr.
judgments are
Aggarwal
there.
was,
So many
what
judgments
Mr.
are there.
Aggarwal was saying was the answer to that question which the gentleman had raised.
Yeah.
That you see, it is ultimately what matters is we have to look at what the mechanics of an agreement is.
Yeah.
As of course, somebody say, even in the example taken by Saurabh regarding the manufacturing of iPhones in India. So if you are paying for something for ensuring that the quality standard, the branding standards and all, they are being preserved, but that is also what in the interest of the foreign company, then obviously PE is something which may not create a straight away business connection of a PE for that matter. So it all will depend on what are the services which are being rendered and for what purpose are they being rendered. So it may not be very much, kind of a general statement, it's not advisable at this stage.
I'll just add one more point, Mr. Pannu, with your permission, to Saurav's point. I think what happens at times is, this is my experience of last 30 years doing all this, is that when you advise a client that these are the do's and don'ts, in practice, actually the do's and don'ts don't happen.
That is the critical. That is
So the point I thought I'll make is that
Mm.
in substance, when you give an advice, the advice is given basically the agreements that you will not do this, you will not do this. And you have seen cases, reported cases of a G where the website is saying we have 15 people in India doing analysis for us.
Yeah.
Now, the tribunal said, well, it is your website which is saying that you have 15 people in India. You prove that they are not working for you. We don't have anything to prove. It is your website, it is your statement, your LinkedIn profile of your employees. So I think the point I would like to address to the people is my experience is that I think there should be an analysis of what is being done at the ground level post the advice taken as to what is A or B or C company is doing factually. Because as substance over form, those facts will decide and not the paperwork. And this is what I think the Supreme Court said.
Absolutely.
Just don't look at the agreements. It is the substance which will make a difference in the end.
They have
So
said
that is
it
more
twice.
critical.
They have said it twice over. Even in Formula One, they have said so.
Absolutely.
It has many words.
Absolutely.
Therefore, that is very important.
Sanjeev
Yeah,
sir,
I thought-
may I request, because we are running out of time here.
I'm
and
done.
with the Pannu sir, before we extend we offer the vote of thanks. Last question from Vijay Goel sir. Vijay sir, please proceed.
Thank you.
Yeah.
Thank you, Prakash. So my question is on the 5.1 phrase, which is fixed place of business through which the business of an enterprise is wholly or partly carried. So now the question is on what is the business of the enterprise? this I am referring to in the context of core business or non-core business. Because at many occasions in the judgment, it has been various cases have been cited and where the aspect of non-core being excluded from the PE is emphasized. But at the end, it is also mentioned that the non-core is not, preparatory or auxiliary. So where is this conflict is there? So I'm not.
No. See, that is what they refer at. You see, what I understand from your point is, you see, there is also, once you hold it to be PE on the basis of the activities which you find deserve to be labeled as PE activities. The second thing comes into your the attribution part of it, the computation part of it. So it is very much possible that non-core activities you may not be doing in that PE. So therefore, it will not enter your profit estimation.
No,
So you have to keep the two perspective. Perhaps that could be the reason.
Separate from the profit attribution point. Question is whether the nature of activities will determine the PE existence or the business of the entity being carried on. So that is my question.
The activities of the PE will have to be seen vis-a-vis your business to see whether those tests are fulfilled or not. You see, this is exactly what, if you read Formula 1, this is where, and also the E-form also, there also the Justice, I think the E-form was Justice Rohinton. That's what he has explained. So just read that. So you have to look at the activities of the entity which is being subject to assessment, and what are the business of the assessee, and how the activities relate to that business being carried out. तो वही तो उन्होंने बोला कि यूए कंपनी का यहाँ पर कोर बिजनेस सेटिस्फाई हो गया once you have so A, B, C, D, 3, 6 happening in India at the premises of AHL.
I'll just give a quick example on this to understand better. So suppose there is an insurance company outside India, which is a parent company, and in India, they set up a back office operation where the job is for the accounting, HR, and other functions like that.
So job back office में तो फिर एक बात ही फर्क है ना. See, there you are servicing all your people in abroad. That's what e-funds was. You had back office here, you're servicing your people abroad. ATMs were all being abroad. So therefore, ये चीज ही फर्क हो गई ना. यहाँ, whereas here is a case where at the ground you were conducting the business. That is what was found by the authorities.
Sir, just 15 seconds, if I may add to what
Yes,
Pannu
yes.
said to address Vijay Goyal ji.
Yes,
I think
yes.
Vijay Goyal ji, आपका problem, आपका जो question है वो ये है that what is core and what is non-core. And with Pannu sir's permission, I would say core is one where the money is directly coming from your activity. Non-core is that money is remote.
Right.
That is the thing. Here, their remuneration is directly linked to the productivity of the Indian hotel. So where is the question of non-core activity here? You are directly earning money from your activity. Sir, I mean, to be a specific.
Yeah. No, ठीक है. वो तो तभी वो बोल रहे हैं कि आपका
So I
core,
think
आपका
so non-core का मतलब ही कुछ नहीं है ना. Non-core का मतलब क्या है कि money may come, may not come secondarily, remotely, something like that. यहाँ तो सीधा आ रहा है ना.
Okay.
I think, sir, we have discussed this case with all the 360-degree angle on this issue here. And it is the time that I should extend my vote of thanks to all the learned speakers here and the chairman. Start with the ladies first here. Really, Diksha has done very well, and in fact, I was thinking that Diksha will supporting Ashish, but it was vice versa here. So with this, really, she was taking the lead here, and she has brought out one of the very important issues here, which has kept us discussing all the way here. Ashish ji, your knowledge in this topic is very exemplary here. You have done a wonderful job here, And you have done a lot of work on this issue of the determining the fact. And actually, you have really raised the issue which was prior to the coming of the treaty into the force. It was not in our knowledge here. It was never came to our knowledge, even though we went to the High Court and tribunal judgment also in these issues here.
So Prakash ji,
Uh,
as the thing moved, it moved just like a normal assessment procedure, with Diksha working more on the facts and bit of law, Ashish working, adding more legal aspects, and when you went to the higher forum with Sanjeev, Mr. Aggarwal, and Mr. Pannu, then it was all a fine tuning of the final legal aspects. And at the end of the session, we come back with listening to and learning whatever was, not only whatever were the facts, but also how to appreciate those facts in the light of the law. So very well.
That is important.
And really thankful to Aggarwal Sahab. In fact, I will tell you the truth here. I have requested Aggarwal Sahab to give some views on the issue of the Hayat, and he was supposed to speak on the issue of the self-drilling here. But the self was never started here, and the self was kept pending here. But I will request him to give this.
Prakash,
Yeah.
shelf drilling is still, drilling is on because it has gone to the third. So one can still wait for it.
Yeah. So, and really the view that Aggarwal Sahab has given, you have given a very fantastic view on how to understand the topic and how the court looks into this matter is really, really a wonderful, sir. And I'm really thankful to Chairman Pannu, sir. It's a really a privilege for all our participants to learn from him, to listen him, and to have a blessing of him. And Sanjeev sir, Pannu sir, all are contemporary, and they have discussed the topic in such a very lucid manner that I'm the really beneficiary of all these things here.
Thank
All
you
the
very much,
participants.
Prakash. Thank you. And in fact, Sunil ji, I had an occasion to hear Sunil ji, but not for very long in this thing in the Delhi. But of course, Sanjeev, we go back together very long time back. I saw on the screen Harpreet also. I can't see him now. Is he there, Harpreet Singh? Harpreet
Yeah,
and
actually, he has to check out due to some. Yeah. Oh, sorry. Yes, he's there.
He's there. Okay. I saw him in the beginning, but then after we didn't see him. I said maybe he's still there or not. So, but it's. I think CTC deserves a lot of compliments for this, and Mr. Hinesh Doshi also joining you from Bombay. So all of you, I think you're doing a great job by getting together and discussing these things. These are very enriching, and they are not enriching for one person only, the listeners, but also the people who participate. We also come prepared. We also get to get to listen and understand the various dimensions of those things. And all the same, I think this is what society is looking for: a set of people who stand by the rule of law and who help in the setting of a rule of law between the different courts and in everyday life also. Why not? All the very best, Prakash. Thank you very much. You guys are doing a
And
good
thanks
job.
to
Thank you.
Vijay Goel sir
Thank you.
also, because he has contributed from questions, sir.
Yeah, Vijay Goel, core non. He went to the core. That was the thing.
Thank you. Thank you.
So thanks to all, sir. This one, sir.
Thank you.
Thank you very much.
Thank you.
Sir. Thank you.
Thank you.
Thank you.
Thank
so
you.
much, Prakash.
Thank you all
Thank
for
you.
sparing your valuable
Thank you.
time, sir.
Thank you.
Thanks.